Iku Iluna, please rise. Aohea o ko I ko ka aha, inahe, kuliana imua o kea, aha ho o kolo kolo ki ike hano hano, o ka moko aina o Hawaii. Inai mai, e malio mai, ilohi ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo, please be seated.
Please call the case.
Case number SCWC-19-0000107. MΑLAMA KAKANILUA et al., petitioners, plaintiffs, appellants, versus Director of the Department of Public Works, County of Maui, and Maui Lani Partners, respondents, defendants, appellees. Arguing for the petitioners, MALAMA KAKANILUA et al., Lance D. Collins. Arguing for the respondent, Director of the Department of Public Works, County of Maui, Kristen K. Tarnstrom, Deputy Corporation Counsel. Arguing for the respondent, Maui Lani Partners, Gregory Kugel. Also appearing is David Abitbol. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you ready to proceed? All right, we've allowed 30 minutes for each side for argument. Mr. Collins, you've asked for 15 minutes and then reserved 15 minutes for rebuttal. We'll give you a warning light 15 minutes in. Ms. Tarnstrom and Mr. Kugel each have 15 minutes. We'll give you a yellow warning light when you have 5 minutes to go in your time. Mr. Collins, please proceed.
Aloha, ai olo olo ai ka'aha ho kolo kolo kie kie. Aloha and may it please the court, Mr. Chief Justice and Associate Justices. This case fundamentally is about the Director of the Department of Public Works issuing a permit contrary to law and threatening injury to plaintiffs' traditional and customary rights and their ancestral burials located in the Kalua Sandhills, the site of the Ahulau Kapi'ipi'i KAKANILUA. More specifically to this court, MΑLAMA KAKANILUA asks this court to review two important questions of civil procedure in which the ICA has gravely erred. First, is the status of Rule 60B, Hawaii Rules of Civil Procedure motions in relation to the tolling of the time to take an appeal under Rule 4 of the Hawaii Rules of Appellate Procedure. The other question has to do with the persistence of fact pleading and plausibility standards in evaluating Rule 12b6 motions after this court issued its decision in Reyes-Toledo. With respect to the first question, this court has twice amended Rule 4 of the Hawaii Rules of Appellate Procedure since the cases that the Intermediate Court of Appeals relied upon in denying relief to MALAMA KAKANILUA. Rule 60 specifies the time within which a Rule 60 motion should be brought. And Rule 60 says...
Rule 60, right?
Rule 60,
yeah,
60, sorry. Rule 60 says that the time should be a reasonable time, and for motions brought under B1, B2, or B3, that it must be a reasonable time, but not more than 1 year. The Intermediate Court of Appeals, however, has repeatedly determined, including in this case, that Rule 60 does not specify a time within which to bring the motion. And the logical consequences of that for trial courts is that there would be no standards then to determine when a litigant brings a Rule 60 motion. The rule itself plainly says it should be brought within a reasonable time, and there would be a determination in each case about what that time is.
Mr. Collins, go ahead.
No, go ahead.
So, Mr. Collins, has the Hawaii Supreme Court or the ICA ever recognized a 60B motion as a tolling motion under the appellate rules, Rule 4, when it is filed after 10 days?
I have not found any cases, and I should say that this interpretation of the language of Rule 60 is also, in the Rules of Civil Procedure, is also applied analogously to like the Hawaii probate rules, Rule 36, and the analogous rules for the district
family
court.
court rules,
And
et
family
cetera.
court rules.
So, Rule 60 specifies that it is for purposes of relief from, and it says final judgment, order, or proceeding. So isn't it a different type of motion than one that is filed under the trial court rules, for instance, the civil procedure rules of 59E, which is required to be filed within 10 days and specifically provides that it is to alter and amend in E. So speak to that if you would.
So Rule 4 says that the types of motions that potentially could toll the time to file a notice of appeal is to amend findings, to make additional findings, for a new trial, to reconsider, to alter, or amend. And relief from a judgment that is based upon erroneous law, based on new case law, would be a motion to reconsider. And Rule 59 doesn't expressly say reconsider. It talks about altering or amending a judgment or having a rehearing. And so if you, in our view, if you look at the progression or the changes to Rule 4 from the 1990s, when the cases that the Intermediate Court of Appeals relied upon, and today, the language of Rule 4 was broadened as opposed to how narrow it was as it was written in the 90s. And in our view, the purpose of that is to allow the trial courts to correct error and eliminate the need to have litigants take appeals.
If you allow a Rule 60B6 motion, which can be filed within a reasonable time, to be a tolling motion, don't you really undo the finality of judgments? I mean, that what is reasonable time? It is potentially very case specific. How are parties to know whether they have a final judgment?
Well, that's a very good question, Your Honor. And one of the ways that has previously been addressed in this rule and how the federal rules of appellate procedure have decided that is there used to be a hard stop, which was 10 days, and that was removed. And so, for purposes of taking appeals, it may be that if this court so feels, that it should specifically say that there is some outer limit to, if it's going to use language that just refers to the specifying of time in another rule, if there needs to be an outer limit to that, it should be stated in Rule 4. Because how is a litigant supposed to know, if it's not in the rule, that there's this secret unwritten rule that actually the rule used to say 10 days and it doesn't say it anymore, but it still is supposed to be 10 days.
Counsel, on that point, I was just trying to figure out what your thought process may have been when you were looking at the rules. And I know these rules, even for the best, can be confusing. You're going jumping between the appellate rules and the civil procedures rule. They're jumping back and forth. Was the thought process for you that you were trying to file the Rule 60 motion within the 30-day appeal time? And that was your backstop, that you wanted to make sure that you got something in within that 30 days?
Well, I think actually the practical litigation purpose was we were hoping that Judge Cardozo would reconsider his view and allow the case to move forward, because my clients were trying to stop burials from being desecrated. And their hope was that he would, after seeing Reyes Toledo, would basically reconsider his decision and they would be able to continue.
No, I'm talking about your timing as far as when you thought you had to get that Rule 60 motion filed. I know it says within a reasonable time, but when you were thinking this through, were you thinking that my appeal time is 30 days, I better file this Rule 60 motion within that time period? Was that the thought process that you were going through at that time? So there was a backstop.
I felt for purposes of if it were contested, which it wasn't, that filing the request for the court to reconsider its decision within the time of taking the appeal. I mean, as soon as Reyes Toledo came out, I mean, it was think we did it as humanly quickly as possible to get the reconsideration motion in. But in my mind, it wasn't challenged, but I thought, well, this would be a good demonstration of reasonableness that we tried to get this motion filed as quickly as possible.
Thank you.
Well, does that then answer your question about what might be a reasonable time to file a 60B6 motion
Well,
within the 4A1 timeframe?
well, Your Honor, for me, yes, I definitely think any motion that is filed within the time of, to take a notice of appeal, in my view, for purposes of Rule 4 and Rule 60 analysis, would be a reasonable time in terms as maybe as a matter of law, but in terms of are there situations where such a request is made under Rule 60 after that 30-day period and whether it's still a reasonable time under Rule 60, in many instances, yes, it probably would be. But in this case, it definitely was taken within the 30 days.
So in listening to your answers to Justice Devin's questions, it seems like you might have been, expecting or anticipating that your notice of appeal deadline would be, after the court disposes of the motion and enters its order at that point. That's your expectation. Were you expecting the ICA to treat your case like a 59E motion?
We were not, Your Honor. That was unexpected, and partly because Rule 4 has been amended twice.
And let me ask you this now. You're calling it a motion for reconsideration. I'm just wondering how flagging a new case, Reyes-Toledo in this case, which really just reaffirmed notice pleading, the standard that the court, I see, actually used notice pleading. And it may go to the merits of your case, but I mean, how is that a motion for reconsideration, just flagging some new case that came out?
Well, Your Honor, Reyes-Toledo said that the standard of well-pled facts are admitted as true, but legal conclusions are described it as one of the two pillars of the plausibility standard. And in our view, Rule 8 simply requires a short and plain statement demonstrating entitlement to relief. And of course, in the other part is the demand for judgment. And whether or not facts are well pled are irrelevant to a Rule 8 analysis. The well pled facts standard is a throwback to fact pleading and the common law forms of action. And it was very clear from the complaint, which was actually slightly more than a short and concise statement, that what was being disputed was whether or not the Director of Public Works lawfully granted a permit renewal or even had the authority to do what he did, and for injunctive relief to prevent irreparable harm to burials and our clients' traditional and customary practices. And so whether or not the facts were well pled or whether or not the short and concise statement could be characterized as legal conclusions is completely immaterial to whether or not a claim for relief was properly stated.
Mr. Collins, coming back to the threshold jurisdictional issue, just looking at the types of pleadings or types of motions that are identified in Rule 4A3, where would you place a Rule 60B motion in there? I'm not. It's not for additional findings, not for a new trial, not to reconsider, alter, or amend the judgment, because it's for relief from an existing judgment or attorney's fees or costs. How does it even fit in those categories of motions that are the sort of first requirement of that rule? Where does it fit?
Your Honor, our view is that it was a motion to reconsider the judgment. The judgment was a judgment of dismissal without prejudice, and we were asking the court to reconsider that in light of Reyes-Toledo and to basically set it aside.
But,
Can you?
Oh, I'm so sorry. No. But you cited Rule 60, right? You cited Rule 60 as the basis for the motion, right?
Yes.
And if you look at all those different motions that are listed there, all of them have very set time frames of 10 days or 14 days. So again, coming back to Justice Ganoza's first question, wouldn't it be certainly an outlier or not consistent with the approach of this rule to have this open-ended reasonable time as a standard for one category of motion when everything else is very set with an exact day specified, and instead for this one particular category of motion, Rule 60B motion, to say, hey, it's an open-ended reasonableness inquiry. It just doesn't seem to fit with all the other rules that are cited there or alluded to.
Well, I know many litigants, including some of the clients I've represented previously, like to argue that Rule 60B is an open-ended inquiry, but it does say reasonable time, and for 1, 2B, 1, 2, and 3, it has to be a reasonable time, and also that reasonable time has to be within a year. But Rule 60 is not open-ended. Each case is very specific. The determination of a reasonable time is very specific, and the rule doesn't say if the rule or statute specifies the date or the number of days. It just says it specifies the time. And Rule 60 specifies a time. But I also agree that, the Korematsu case was brought up on the common law version of a Rule 60 motion, the writ of Corbin Nobis, and that was like decades later. I guess it was reasonable because they granted him his relief, or maybe the U.S. government didn't oppose it on that ground. So I do agree that one of the logical consequences of reading the rule based on its plain language and recognizing a Rule 60 motion is, in this case is a motion to reconsider, may significantly extend the time for a notice of appeal being taken. Because before the 90-day limit starts, you have the situation of how long is it that such a motion could be filed. The rules previously addressed that by limiting that to 10 days, and the federal rules of appellate procedure have addressed that issue by limiting it to 10 days. But our rule no longer has that limitation in it.
Is it 10 days under the federal rules? I thought 59E was 28 days.
I'm sorry, for Rule 60, it's 28 days, but for Rule 59, it's 10 days. And so that would be that may be the logical consequence, but that's the rule that we have before us today. And that was the rule that MΑLAMA KAKANILUA relied upon, seeking the Second Circuit Court to reconsider its determination regarding.
Counsel, I'm sorry to interrupt. Can I ask you, the Simpson case was trying to balance, the harsh results that can happen, denying someone their day in court. But we also have to balance finality as well, which is what I think Justice Ganoza is alluding to, and which I agree with. But didn't Simpson say that a Rule 60 motion is not a tolling motion? And if it said that, how do you square that with the position you're taking now?
Well, it said that it wasn't a tolling motion because of the way that Rule 4 was written in the 1990s.
I guess that was my next question.
Oh.
Were there any changes since then that would change the outcome in Simpson?
So Rule 4 in the 1990s specified every kind of motion that was a tolling motion, and Rule 60 was not among that list. But the cases that the ICA relied upon construed Rule 60 motions as Rule 59 motions for purposes of tolling if they were brought within the time frame of Rule 59.
What legal authority did they base that on? When I looked at the case, they were citing to Morris. But that seemed to be about it.
Yeah, and Your Honor, the name of the case escapes me, but I believe that this court subsequently has also said that treating Rule 60 motions as Rule 59 motions for purposes of figuring out whether something met a deadline, and the purpose of that was to allow litigants to have their issues resolved on the merits. I think the underlying principle is that to the extent possible, that claims should be resolved on the merits as opposed to counsel misnaming a motion, even though the relief sought is basically the same as under a Rule 59 motion.
Thank you.
Counsel, if we were to rule in your favor, but we feel that there has to be some sort of limit for tolling, what do you think would be the reasonable limit? 10 days, 28 days, 30 days? Because there does, now, Rule 60 clearly says that the filing of a 60B motion does not affect the finality of judgments. And so if an appeal is not filed within 30 days, right, parties should be able to, the prevailing party should be able to rely on that to say that this is now a final judgment. So do you think 30 days would be like the most outer limit that should be considered? Because I mean, it is kind of strange to say that Rule 60B says that a 60B motion does not affect the finality of judgments, but then to say that if a motion for a 60B motion is filed on the 35th day, even though the judgment's not final, it still tolls the appeal deadline. You can still consider the merits of the appeal. So I'm really having a problem going past 30 days on this issue, because 60B also says that, you know, this rule doesn't affect parties' ability to file a separate lawsuit alleging fraud on the court, et cetera, right?
Yes, Your Honor, and actually motions for rehearing and motions for reconsideration historically were considered the first form of an appeal. And so, I mean, as I answered earlier, that we tried to get this in as soon as possible after Reyes Toledo was decided. But definitely for purposes of reasonableness, we did try to get it in under the 30-day window, because in our view, we felt that we would be able to argue that it was a reasonable time to bring this motion. And so, in my personal view, I believe that a motion for reconsideration that's brought within 30 days unquestionably is reasonable under Rule 60. And for operations of tolling the time for Rule 4, I think it's reasonable. If the court adopts that, hopefully it does it in the rules so that persons who look at the rules can rely on it and understand clearly what's being said. I do want to mention one thing about finality, is that the judgment was a judgment of dismissal without prejudice. So it's a little bit different. There wasn't an adjudication on the merits. It was the trial court judge said that there was no claim for relief, and so it's dismissing.
That was my other question. Why was it without prejudice?
Well, in the other side did ask for prejudice, and it's not stated in the record, but my impression or my understanding of why it was without prejudice was because the trial court basically ruled that there was no claim, so he couldn't do it with prejudice because he ruled that there was no claim being made, and so there's no res judicata over the lack
Was
of
anything
bringing a claim.
refiled after that?
Just the appeal.
Right, because you were asking, you really wanted to amend the complaint anyway, right? I mean, isn't practically it gets dismissed without, you can do what you want to do with the complaint?
Well, that would have been an alternative if we had some guidance about specifically what was lacking, in terms of what was missing from the short and concise statement. We would have asked for leave to amend, but if
So there was an allegation of no private, one of the defenses was no private right of action. Is that right?
that was for count one, that was the issue. It was raised under 6E, which allows any person to go to the environmental court to get injunctive relief when there's threatened harm to historic properties.
Didn't we kind of address that in the Kalei-Kini case?
Yes, Your Honor.
And was that argued in the environmental court?
That count one stated a viable cause of action?
Right, that it's really a standing issue. It's not this private right of action issue.
None of that was addressed.
And
Your
the
Honor.
standing exists for descendants.
Yes, Your Honor. And we felt that both in the complaint, facts about the plaintiff's standing was specifically alleged, and definitely in the moving papers with the declarations, all of that was provided. And so we do feel that with respect to count one, that the dismissal was wrong because the threshold is there are no set of facts that the plaintiffs could prove that would entitle them to relief. And on the face of the complaint, if those facts were held true, there definitely was a basis to grant relief.
When the dismissal was entered, though, you're still within the statute of limitations period to refile if you had chose to do so.
Yes, Your Honor. Yes, but the problem that we were coming up across is that this is actually the second case where the trial court judge had made a determination that there was no cause of action. So it's sort of like, well, we could keep refiling and keep getting the same result.
No, and I understand you're looking for more information to understand what it is the court was looking for. I understand the point.
But I do have to say, one thing that did come up in the very brief, 32 documents that were filed in the underlying case was when plaintiffs filed the case, they weren't sure how long the director had before he issued the renewal. And they thought, well, it must be at least 4 days because that's when the injunction in the other case was issued. But then it turned out in the moving papers, they find out it was a mere less than an hour between when the request for the renewal happened and when the renewal actually happened. And so I think that goes back to what is the correct standard for Rule 12b-6. And the purpose is to allow discovery or other pretrial processes to go forward to allow plaintiffs to fully develop their claims. I mean, the rule for amendment says that proof shown at trial will automatically amend the complaint. But the way that the standard about well-pled facts and legal conclusions, it just is a throwback to fact pleading and common law forms of action where one misstep or one typo by counsel basically completely destroys the case. And in our view, that goes contrary to our court's policy of trying to decide cases on the merits and allowing courts to be accessible to right the wrongs of the people in our community. And at this time, I see that I've gone well over my time, so I would like to yield
Reserve
now.
your time.
Yes,
All
thank
right,
you.
thank you, Mr. Collins. Ms. Tarnstrom.
May it please the court. My name is Kristen Tarnstrom. I'm here on behalf of the Director of the Department of Public Works. This action was simply one small front in the litigations between the appellants and Maui partners. The true battle was the original litigation between them. Appellants in the original case alleged that Maui partners' grading and grubbing activities violated HRS 6E, appellants' constitutional rights, and did so by disturbing burials, violating an archaeological monitoring plan, and other zoning allegations. After a several-month injunction, the trial court allowed grading to recommence, and it provided specific concessions to the appellants. And before that matter was settled, the Director of Public Works was approached to extend the time for the grading permit. After reviewing the court order that expressly allowed the developer to start grading again, and after hearing nothing from SHPD about his concerns that he transmitted to them, that the appellants had made, but he had been unable to verify, the director issued the time extension. Appellants used this action, making these claims against the director as a collateral attack to stop the development. Judge Cardoza dismissed those claims without prejudice, despite them having no legal foundation, so as not to disturb the original important action. He made that explicitly clear in the order granting the motions to dismiss. The ICA cut through the fog of the briefing in this case and issued a clear and correct analysis regarding the untimeliness of this appeal. They also rightfully upheld Judge Cardoza's denial of reconsideration because that was the only possible conclusion. He had applied a notice pleading standard on a 12b-6 motion, and there was simply nothing to consider based on Reyes-Toledo 2. We want to address three broad points here. The first, that the ICA accurately determined it did not have jurisdiction over the appeal generally. Second, the ICA accurately determined that Judge Cardoza did not abuse his discretion in denying reconsideration. And finally, that the court should the court be inclined to review the merits, there was no foundation made for the claims in this case. As to timeliness, Hawaii Rule of Appellate Procedure 4A3 is at the center of the ICA's decision. The language of Rule 4 is clear. Appeals must be filed within 30 days unless they're told pursuant to rule. As to tolling, if there is a timeline specifically set forth,
Counsel, is the word tolling appear in the rule?
I don't believe it does.
It says extend, right?
It says extends the time to file an appeal, correct?
Tolling is a little bit different, isn't it?
Yes. As to tolling, there has to be a timeline. It specifically states court or agency rules specify the time by which the motion should be filed. You must have a motion, you must have agency or court rules that specify the time it must be filed, and it must be timely filed.
Well, counsel is arguing that the specified time is a reasonable time, and that's for the trial judge to decide upon. Why isn't that acceptable?
Thank you, Judge. The reasonableness question under a 60B is open to broad interpretation. A court, in considering reasonableness,
It's a case-by-case analysis, isn't it?
takes into account the equities of the case, the prejudice to the parties, the finality of the judgment, and the
It's also
reasonableness.
because we can't anticipate every situation that's going to come up, so we have this catch-all rule, but it's bound by reasonable time. Isn't that a specified time period?
I would say no, Your Honor. The rule requires, it specifies the time by which the motion shall be filed. There is nothing in Rule 60B that references a time frame in which it shall be filed.
Right, but there's nothing in Rule 4 that says it has to be a number of days either. It just says specified time, and reasonable time can be interpreted as being a specified time.
Well, specifically, Your Honor, Rule 60 specifically states, as Justice McKenna stated, that subdivision B motions does not affect the finality of a judgment or suspend its operation. So the intent of 60B was not to create motions that would extend the time to appeal. They can only be extended in this court's precedent, as well as a lengthy historical or precedential record, that those motions can only be considered essentially quote-unquote tolling motions if they're construed as a Rule 59 motion. And that is true from this court's decisions in Simba John and its recent decision in Cole. All of those decisions were cases that were 60B motions filed within 10 days of the filing of the judgment.
Right, and the
treated
court
as-
seemed to be doing that to avoid the harsh results that would result to a party not having their case, having their day in court. I mean, that was the consideration behind that, wasn't it? Because they were simply converting a Rule 60 into Rule 59 if you filed it within 10 days. That was the analysis there, wasn't it?
Yes, and I think the court was balancing the interest in finality with the interest in providing a non-technicality if you filed the motion under the wrong
Why
rule
shouldn't
number.
we balance those same considerations here for Mr. Collins' client?
I believe the Rule 60B6 motion in this case was filed within the appeal deadline. It could have just made an appeal under that same analysis that Mr. Collins raised in his 60B motion. Again, it didn't raise all of any other concerns that are related to 60B. And it was within 27 days of the entry of judgment. No court, as this court has already questioned, has considered a Rule 60 motion to toll the deadlines to appeal unless it is filed within 10 days of the entry of the judgment.
Ms. Tarsham, you were talking about the backdrop of this case, the broader, I guess, litigation going on between the parties. Given the order dismissing without prejudice, was there, why not just, why didn't, in your view, petitioners just refile an amended complaint? What was it in the broader scope of things that, is there something in the broader scope of things that would have made that unrealistic?
I think that I can't speak for Mr. Collins and
Right.
what appellants were thinking. My thought was that this case was just an attempt, last-ditch attempt, but an attempt to once again attack this time extension that the director issued in order to invalidate the permit. And that was an attempt to get around the original orders issued in the other case. And the court was very specific in not wanting to harm any part of the original case by issuing this dismissal with prejudice. So we wanted to keep it alive. We wanted to give the appellants the opportunity to continue to raise important concerns about how the grading and grubbing was continuing. But in this action, there simply was no there. Just to go back, there were 2 filings after the judgment in this case. There was a bill of costs filed, and just note that a bill of costs is not a motion, and nor does it toll the time to appeal or extend the time.
Counsel, it is the planning department's position that plaintiffs here could not challenge the extension, correct? That they didn't have, there was no private right of action and or there was no standing to challenge the extension, is that right?
It's the Department of Public Works in this case.
Sorry,
Just to
Public
be
Works,
clear,
sorry.
no, that's fine.
Sorry.
The department's position in this particular case, where these 2 claims were brought, challenging that the director did not have any authority to issue this time extension, and they brought the claims under HRS 6E and the Quo Warranto action. Under those allegations, it's very clear that the department and the director had the authority to issue the time extension. In the original action...
Let me ask you this. This was based on some request, right? And according to the appellant here, petitioners, the request was granted within the day or an hour or so. Is that right?
Yes.
Now, would the rule, the ordinance does seem to say good cause or hardship. Is that right? That's the standard?
It says the director may extend the time for the permit in cases of good cause or hardship.
Good cause or hardship. Okay. So it is your position that the petitioners have no constitutional Article 12, Section 7 concern with respect to whether a grading permit can be extended without hardship or good cause.
If I understand your question.
Right.
Our
I
position-
understand the rule says hardship or good cause, but your position is that there's no way they could challenge that anyway. Is that right?
Well, I mean, they could potentially challenge it through an agency appeal if they had standing and there was a appropriate means to do so. But they're challenging essentially the exercise of discretion of the director. And that's the entirety of this case.
Is it a discretion? It doesn't say discretion. It says based on good cause or hardship, right?
But that's in the director's mind. There's no requirements for good cause or hardship. There's no statutory requirements of anything that an applicant would have to meet. It's just whether there's good
so
cause.
it can just routinely. So the director could have sua sponte granted the extension even without a request because it's completely discretionary and without any showing of good cause or hardship. In DPW's view, the director could have extended the
There's no requirement for a showing of good cause. So yes, I would agree with you. It's within what the director considers to be a good cause.
With no explanation or even, it could have been discretionary, as you say.
Yes.
Without any request, the director could have extended it.
Right, and in this case, there was a direct request, and that was in the motions for summary judgment briefing. But not to get too far into it, but you asked whether or not the extension could ever violate the Article 12, Section 7 rights. I think the questions here was whether there was a requirement under 6E, which is bound up with the traditional and customary practices argument. Article 12, Section 7 says, the state reaffirms and shall protect all rights customarily and traditionally practiced, subject to the right of the state to regulate such rights. And there's extensive regulation by the state under HRS 6E and its 12 sets of administrative rules. The administrative review process is set forth explicitly in those rules. And with respect to the director's administrative action in reviewing and considering a time extension to an existing valid permit, as long as he follows the prescribed rules, the constitutional protections are in place. And that's not to say that if harms occurred outside of of that extension. Say if grading on the ground still caused harm, they could reignite a different case, or they could reignite the original case, which was kept open for them to raise violations of the archaeological monitoring plan and other issues. But here, there's no requirement in statute, administrative rule, or county code that they reconsult SHPD on a time extension. And that makes sense in the scheme of things because SHPD reviews is a project level review, and that's been discussed at length by this court in Kelly Kinney.
Let me ask you one follow-up question. Could the director have extended the grading permit? Let's say that the time had actually expired. Could the director have extended it nunc pro tonc back to the original expiration date in your view?
That wasn't the case in this case. Hypothetically, I'm not sure about retroactive application of an extension. It's likely within his powers. Again, the discretion isn't a question in this case. Appellants have stated several times over they're not challenging his discretion. They're challenging his power to grant the extension. So if there was some abuse of discretion and they could raise it through the Board of Variances and Appeals or otherwise, then it could be addressed in that way.
Anything further, Ms. Tarnstrom? You're coming up with about a minute to go.
I see. Okay, thank you. I just wanted to add, this case is about one single action. It's about the time extension for a grading permit that was validly issued. And that extension, to give them more time, was fully within the director's control. It was not ultra vires. The director did not usurp the role of the county council, and it wasn't outside the law in any manner. And this administrative act, in compliance with the spirit and the language of 6E, could not have harmed appellant's constitutional rights based on the admitted facts of this case. The trial court found this case had no legal foundation. The ICA found the appeal untimely. Both were accurate in their assessment. We asked the court to affirm the ICA's decision. Thank you.
Very well, thank you. Mr. Kugel.
Thank you, Chief Justice Rechtenwald, Justice McKenna, Edens, Ginoza, and Devens. May it please the court, I'm Greg Kugel, and I'm here speaking on behalf of MALAMA Partners. I think the appropriate place to start, given the issues and the questions at the outset of this case, is what this court said most recently 6 months ago in Cole versus City and County of Honolulu, where this court looked at Hawaii Rule of Appellate Procedure 4A specifically. The court noted two things, and I'll quote. HRAP Rule 4A3 reveals an objective to impose finality and a definite appellate deadline. And then secondly, the court said, we believe that a sound rule does not permit an appellant to revive a case decided final judgment-wise years before. An ideal rule promotes finality and sets an easy-to-understand notice of appeal deadline. With that context, and that was just 6 months ago, the Intermediate Court of Appeals announced the Simpson decision over 25 years ago, in which it stated the general rule that has never been questioned by the courts in this state, the appellate courts, and that is a Rule 60B motion is not a quote-unquote tolling motion. I agree with Justice McKenna, more properly the term should be extend, but the courts have called those tolling motions. A Rule 60B motion is not a tolling motion, with one narrow exception, and that is if counsel, in filing it, seeks to make a substantive change to the underlying judgment, then it is deemed to be, in effect, a Rule 59 motion, which has the 10-day limit. Throughout various iterations over 25 years of the of Rule 4A3 of the appellate rules, the ICA has been consistent, and twice this court has considered appeals from 4A3 and interpreted it. Originally, this court did it in Sakuma, which was cited in the briefs. That was in 2013, and that was the case where this court said the ICA should not have dismissed for lack of jurisdiction because there had not been a ruling on a timely filed. That was this court's words, and the underlying ICA decision and this court's decision show in Sakuma that was a Rule 59 motion and was filed within 10 days. So it was a timely filed motion. This court said that appeal should be considered. Flash forward to 2024 in February when this court considered Cole. This court said the same thing. Justice Eden's writing noted that it was a timely filed motion. And if you look at the dates given between the date of the judgment and the date of the motion for reconsideration in that case, it was 10 days. And so that has been unquestioned. I noted the three reported ICA cases being Simpson, Samba John, that was followed by Lambert versus Lau in 1999. There have been a host of other ICA decisions, reported and unreported. It was not in
the rule has changed over time, and so the language that we're dealing with now is talks about whether the rules specify the time by which the motion shall be filed. So why isn't Mr. Collins correct that a reasonable time is, albeit an open-ended one, is nevertheless a specified time?
Well, the rule was exactly the same today as when this court issued the decision in Cole, in Ray Cole, or Cole versus City and County.
Understood, but that didn't address this exact issue, did it?
It did not.
Okay.
It did not, but it hasn't changed. I would.
But if we're going back to Simpson and 25 years, the rule has kind of changed over the years from specifically citing specific rules to more general language to where we are today. And, you know, again, that's where we are today identifies motions by type, not by rule, and then imposes requirement of the rule specifying the time. So his argument, I guess, two-part. One is the motion was, in essence, a motion to reconsider. And second, that there's a rule that specifies the time, that it has to be within a reasonable time.
Let me answer that directly, Your Honor. And that is, that very issue was considered by the Intermediate Court of Appeals in the case In Re Zadalis. The citation to that, that's an SDO. So I will be upfront about that. 153 Hawaii 264 decided in 2023. In Re Zadalis directly addressed—
Which court?
The Intermediate Court of Appeals. It was a case coming out of the probate courts. So the Intermediate Court of Appeals was interpreting Probate Rule 36, which they noted in that opinion was the direct corollary to Civil Procedure Rule 60B-6 or 60B. And in that case, they rejected the argument that a reasonable time is a specific—
Was there a cert app?
I do not know that there was, Your Honor. I assume not, because it was just reported as that without a caution that there was a cert app. And I don't believe there was a subsequent decision from this court on that case.
What was the reasoning? Because I assume you're citing it for its persuasive value.
That's right, Your Honor. They explained that a quote unquote, a reasonable time is not the specific time, the certainty that's required by all the references to all the other types of rules under 4A3, which is to reconsider, to set aside, to correct or amend judgments. And that, all of that harkens back to the original reason that the ICA in Simpson announced this exception for Rule 60. I mean, prior to that and to this day, I think this court's never questioned it, both in the Sakuma decision as well as in the Cole decision. If it's a timely filed reconsideration motion, whether cast as Civil Procedure Rule 59 or 60, timely is filed within 10 days, that leaves open the appeal period. But everything else in a reasonable time runs afoul of this court's concern expressed in the Cole decision, that there is supposed to be clarity and finality of judgments. And at a certain point, that has to go. And there's nothing under Rule 60B as—
But in that case, what was the holding of that case? We actually allowed the consideration of the merits, did we not?
You did, because there was no order entered.
Exactly.
5
The rule
years
was
later.
not followed. And so, you know, we're saying maybe the rule needs to be changed, but the rule as written was not followed. So here, we're really just dealing with whether a reasonable time corresponds to a time specified in the rule.
Cole was very different. That was a timely Rule 60 reconsideration motion filed within 10 days of the judgment. And that left it open. This, in this case, was not a timely Rule 60 motion. It was filed more than 10 days, almost 30
Why?
days.
Where is the deadline for Rule 60? Rule 60
Well,
says it's
Rule si-
within,
Rule 60 has two deadlines,
Right.
Your Honor. Correct. There's the 1 year maximum for certain of those types, 1,
Right.
2, and 3, and then all of them within a reasonable time as well.
was this a 60B 1, 2, 3, or 6? I can't remember now.
This case was 60B6.
So it's not even within, the 1 year doesn't even apply here.
It doesn't. You can imagine a circumstance, Your Honor, where new evidence comes to light 10 years later. You've had a case that's been final. Parties have relied on that. Property's been sold or bought, whatever the underlying facts were. And suddenly, new evidence, new law comes up, and somebody goes to reopen that under Rule 60. Certainly, Rule 60 allows a court, if it determines that that's a reasonable time, to look at what the issue is that's being raised by the Rule 60 motion. This is a different issue. Was it timely for tolling on the appeal that reopens the entire appeal? And it just runs, to leave that open-ended as a quote-unquote reasonable time is contrary to every other type of rule cited in Rule 4A3.
They all have time frames, 10 days or 14 days. Isn't
That's
that right?
correct, Your Honor.
But if, a party files a Rule 60B, whatever, 3 years later, and it's deemed to be not reasonable, isn't that still a tolling motion under the analysis by the petitioners here?
That would be a tolling motion. They could then appeal that and open up the whole case, not just the question of was that reconsideration motion denied on the grounds that it was an unreasonable amount of time.
So your argument is that we should follow Simpson and the ICA cases that treat 60Bs as 59Es, even though the rule at that time specifically did not include, our 4A4 at that time had specific motions that would be considered tolling or extension motions. And the reason the ICA adopted the position it did at that time was to allow consideration of the merits. But you're saying we should now treat this as a 59E so that the merits cannot be considered. The merits of an appeal cannot be considered. We can only consider what was raised in the motion for reconsideration.
That's generally correct, Your Honor. The only qualm I
How
have with
is a
that
litigant
is
supposed to know? How is a litigant reading? Let's say we're not even dealing with counsel, but let's say we have a self-represented litigant that looks at 60B and says, I have a reasonable time. Okay, gee, I have 30 days to appeal, so maybe, I'll just file a motion for reconsideration, right? How are they supposed to know that, oh, no, it's the 10-day deadline under 59E? When 59E says new trials, motion for new trials, it refers to trials. It's intended to allow people to request a new trial. And this is an MSJ situation, and now we're going to apply a new trial rule to an MSJ situation. How is a litigant supposed to know that that's the rule that's going to be held to apply?
Your Honor, it's hard for me to answer for that hypothetical litigant other than to say this, that there are many statutes, there are many rules, and this court interprets them all the time. That's what courts do, that are not that clear, but through the decisions of this court and the Intermediate Court of Appeals, federal courts, they develop a body of law that explains things like that. Just like if I were to read the statute of limitations, it seems like 2 years is very clear, but there's this discovery rule that was created by the courts that says, well, that's extended. If I was the pro se litigant, I wouldn't know that.
But that
Lawyers
actually
do.
helps the pro se litigant. It helps consideration of the merits. And we have so much case law saying that we try to address things on the merits. We don't like dismissing appeals. And, you know, if we're going to err, we're going to err on the side of access to justice, consideration of the merits of issues, right?
There certainly is a huge body of case law, Your Honor, and I don't disagree that this court favors and the lower courts favor adjudication on the merits. There are certain parameters that are set, and I would just point to this case specifically. First off, it was not a pro se litigant. Second off, within the time period to appeal, they could have filed the appeal. They filed a motion for reconsideration. They filed an opposition to a bill of costs. So they had the opportunity and they could have done it. It wasn't the hypothetical pro se.
I know, I am assuming the environmental court issued the final judgment, right? But under our law, is that really a final judgment for res judicata purposes?
No, and I'm glad you asked me that because previously you had asked Mr. Collins why the court dismissed this without prejudice. And I think as Ms. Tarnstrom said, and
I've taken a look at the order,
yeah,
so I can see it's referring
he was
back.
concerned, and I think that's very important to the questions you were asking. Again, that's not in this appeal, but Judge Cardoza had went through a multi-day preliminary injunction hearing, heard a lot of evidence from both the plaintiffs and MALAMA partners about the project, and issued a preliminary injunction order that did not allow grading to go on absent some very important restrictions. He gave the plaintiffs access to observe the archaeological monitor and the construction activity. He said, you have an immediate door to court if anything is violated. Come back to me. And in his order dismissing this case without prejudice, he wanted to preserve those rulings and that status quo. So he was concerned about it. And it was not the case where these claims had not been heard.
And was there a final judgment in that case?
That case ended with a dismissal without prejudice and a settlement agreement that in part reflected the terms of the preliminary injunction order.
So it was a settlement agreement.
Yes.
Anything further to wrap up, Mr. Kugel?
I'm sorry, can I
Oh, I'm
ask one
so sorry.
question, Chief Justice?
Apologies.
Yeah, I'm sorry. You know, you mentioned that it wasn't a pro se litigant. We know that, you know, it's an experienced attorney in Mr. Collins. But, you know, his good faith read from everything I've read and heard from him is that he honestly felt that the Rule 60 motion qualified under Rule 4. And shouldn't this court continue to follow the policy that we've been following for a very long time to allow clients, parties to have the cases heard, give them that opportunity whenever possible? Why should we deviate from that for this situation where he did file it within 27 days, so he's still within the 30 days of appeal? Why not give them a break on that?
Justice, I think that's a fair question. This court, if it is creating new law or a new rule, it is certainly an open book. You have to balance that policy on the one hand with what you said in Cole on the other, because we're not just talking about some preliminary activities in a case, we're talking about the finality of judgments. And this court recognized that that is important as well. And I think those two policies can be at odds. I think you do or should respect the idea of precedent and stare decisis. Now, this issue has not been before this court, so you do have a blank slate. But there are legion ICA cases as well as both the fundamental underlying assumptions of both Sakuma and Cole that a reconsideration motion must be timely filed to raise
And the rule
these
was
questions.
actually, 4A3 was actually changed since after Sakuma. But again, you keep talking about the finality of judgments. Under our law on res judicata, this judgment wouldn't have been final until 30 days after the final judgment issued by the environmental court and an appeal had not been filed, correct? So this motion for recon was actually filed within the time before this judgment became final, because our law is different from federal law. Federal courts, the judgment, the trial court's judgment is a final judgment for res judicata purposes. Our judgments are not final judgments for res judicata purposes until the appeals are exhausted.
I do understand and agree with that. It is, I think what's at issue in this case is the scope of what that appeal looks like. Does a untimely, in the terms of the Intermediate Court of Appeals, Rule 60B tolling motion open up the entire case, or does it mean that this court only rules on the Rule 60 argument, whatever it was, which is not necessarily the whole case? And that's the answer, Your Honor. I hope that does. Thank you.
Anything further to wrap up, Mr. Kugel?
I don't. I would, well, one other point, which was the second issue on the cert application, and just, I won't even belabor it other than to say that the review of a motion for reconsideration is, under Hawaii Housing Authority, cited in the ICA's decision, is abuse of discretion. And I would suggest that Judge Cardoza did not abuse his discretion when he said that Reyes Toledo did not change the law, nor did it change the analysis that he went to when he dismissed this case. He took all facts as true, disregarding conclusions of law or legal conclusions, and dismissed the case. And so the recon motion was not, denying that was not an abuse of discretion. Thank you.
All right, thank you, Mr. Kugel. Mr. Collins, your rebuttal.
Thank you, Your Honor. There was a lot of things that were said, and I hope I can address the most important ones. The petitioners entirely reject the legal position of the county that the director has unbridled or unreviewable discretion and can determine that something that is not good cause can be good cause for purposes of renewing the permit. There's no authority for that in this jurisdiction, and the petitioners entirely disagree with that. The second point that was raised by the county is, well, the petitioners could have filed an agency appeal, but that's not correct because the decision of the director in this case is not subject to review by the Board of Variances and Appeals. And so this case is actually very much like Gatry v. Blaine, which is at the time that Gatry v. Blaine was filed in the Second Circuit Court, there was no provision that allowed any kind of review of the Director of Planning's decision. And so the Supreme Court in that case ruled, because there was no process, there was no administrative process to appeal the decision of the director, that an original action in the Second Circuit was appropriate. So in this instance, the county has not cited any authority that the Board of Variances and Appeals would have had over the director's decision in this case, and because of that, there is no administrative remedy
Mr. Collins,
to exhaust.
we've heard a little bit about what has happened in the other case, whether it's the main case, I'm not sure how you would describe it, but that there was a settlement there apparently. Is this particular case moot?
No, Your Honor. This case is not. This case is not moot. The other case wasn't the main case. The other case was that there was, in the petitioner's view, illegal sand mining occurring at the Kalua sand dunes. That it was violating the grading permit and it was violating the archaeological monitoring plans. It was disturbing and desecrating burials and other historic properties. And after a 2-month, not every day, but after 2 months of evidentiary hearings before Judge Cardoza, with myself and Mr. Kugel, Judge Cardoza granted a preliminary injunction, which added a number of conditions to ensure that the archaeological and monitoring plan would be followed. So that was one of the cases, and after this case was decided the way it was, the parties did come to a settlement that protected the terms of the injunctive relief.
Okay, just real specifically, this particular case deals with an extension of a grading permit, right?
Yes.
Okay, so that issue is still a active issue for purposes of what is going on.
Well, there is, according to my clients, there's still some kind of grading going on in the area, but whether or not it's an extension of this permit, no, because this permit, I mean, the decision has been taken only lasted a year, so that year came and went like 6 years ago, 5 years ago. But to the extent that this court would determine this to be moot, we definitely feel because of the short timeframes involved that the exception to mootness or the public interest exception should apply if mootness is considered, although nobody's briefed that. I should say there were other lawsuits too. Some of them are still in states of appeal, but one of them was the archaeologist that was supposed to be supervising all of this. Judge Cardoza voided her archaeological works permit in another case that MΑLAMA KAKANILUA brought because she basically wasn't qualified to be, and that's part of the problem with this was that she wasn't qualified. But to get back to this particular issue, in addition to the fact that our position is that the director should have consulted with SHPD because 6E42 says approval of any project, and if you read the definition of any project, it says any activity, and that a permit renewal is an other entitlement of use, that there should have been a consultation with SHPD specifically about the request to renew the permit. But even that aside, the preliminary injunction evidentiary hearing demonstrated that the terms of the actual grading permit were violated. And so the question is, how can there be good cause if the terms of the grading permit itself were violated? And that's something that goes back to count one, and there was a short and concise statement that was pled, and it should not have been dismissed under 12B6. And frankly, based on the state of the record, our position is that summary judgment should have been granted because there was no evidence to demonstrate a good cause as a matter of law. And I see that my time...
Any other points you want to?
Well, there's just one point, and there was in the discussion regarding whether or not a motion that was filed under Rule 60B that was filed in an unreasonable amount of time would still allow some kind of tolling or extending the time for a notice of appeal. I would just note that Rule 4 specifically says that the extensions of time are only for timely motions. And so a Rule 60B motion that is not filed within a reasonable time would not extend the deadline because it would not be a timely motion, which is one of the conditions precedent for that whole section.
Because the motion would be invalid, right?
Because the motion would not be timely.
Right.
Yeah. So our position is that a motion that was not filed within a reasonable time would not trigger the extension under.
And that would cover the 3-year hypothetical that somebody files it 3 years later. The court says, that's not reasonable. I'm not going to even listen to you.
That would probably cover, depending on what the specific facts are, that would probably cover
And
that.
therefore, you would not be able to appeal that.
Yes.
There would be finality.
Yes. And then one other point, I would just say that actually in our view, Rule 60 only specifies one time, and that is a reasonable time. The 1-year limitation is not a second type of specifying time. It's actually a limitation on the determination of reasonableness.
Mr. Collins, what about the language in Rule 60B that Justice McKenna cited that the motion does not affect the finality of a judgment or suspend its operation? Doesn't that suggest that 60B motions are different from those that are identified in Rule 4 and different from a 59E motion, all of which are sort of trying to retool a judgment that's been issued but not yet finalized? This is now talking about coming in after the fact. And it's just sort of a different purpose, different type of relief that's being sought. So could you respond to that?
Well, it's just that the motion itself doesn't affect the finality, but if it's granted, it definitely will affect the finality of it. And so, I mean, I think this is an issue of, judgments can be executed on. There's, post-collection efforts and so forth for judgments that can occur. And basically that purpose of that is to allow the judgment creditor to pursue its thing and not use a Rule 60 motion as a way to block collection for some amount of time while it's being ruled on.
But if the rule says it doesn't affect the finality of the judgment, don't you have to go, isn't that a signal that you need to file your appeal? Wholly apart from whether you file the 60B motion or not? Kind of comes back to my earlier question, which is I don't see where the Rule 60B motions fit in the list of motions that are identified in Rule 4.
Well, the fact that it doesn't affect the finality if you're seeking the court to reconsider it, that it doesn't, I mean, that doesn't, if the court grants the motion, then that will be the end of the finality. But just, it's basically saying the filing of the motion doesn't affect the operation of the judgment for purposes of Rule 60, but that doesn't mean that it would terminate.
Wouldn't it be for purposes of anything? I mean, the fact that you filed a motion doesn't affect the finality of the judgment. Doesn't that imply that whatever, when the judgment becomes final, or if the judgment is final, you have to fulfill your obligations under the rules of appellate procedure to appeal it?
Except if you file a timely motion to reconsider based on a rule that specifies the time within which it should be filed. So I guess I don't want to be talking in circles, but our view is the purpose of that is to make clear that Rule 60 motion doesn't basically suspend all of the post-judgment proceedings that can be done to execute against a judgment.
Counsel, in your view, 4A3, who decides, which court decides whether the motion was filed within a reasonable time? Because the motion is brought in the trial court, but it's the appellate courts that's. So what would this rule then require a remand to the trial court to decide whether or not it had been filed within a reasonable time to determine whether or not the time period for, the tolling provision would apply?
Well, Your Honor, we think, first of all, that's a question of law that this court can decide. But secondarily, the trial court did not find that it was, the trial court did not make any determination about that, and the parties also did not raise it in any of the briefing.
So it was the appellate court that decided, they didn't even address reasonableness, right? It just said, the ICA said it had to be within the 10 days, so.
Well, I think nobody addressed it because I don't know that anybody's claiming that it wasn't filed within a reasonable amount of time. So I think that's why nobody's addressed it. But we would ask not that this be remanded on that question because maybe this case will never be decided and will strike against the policy of having finality one way or the other. But if I could just make a concluding statement, I know my time
real
is.
Quick, to be clear, the 60B issue here really affects whether, if your reading of 4A3 is adopted by this court, we would go back and review the entirety of the order dismissing the case, right? On standards of review based on an initial appeal, basically, as opposed to if your 60B motion is not a tolling motion, for lack of a better word, not a tolling motion under 4A3, we would review it under 60B standards of review. We would still review it. We would review the order denying that motion, but it would be reviewed under those standards, correct?
Yes, and it would only be as to count 3.
Only as to count 3?
Yes.
Right, okay. Because that's the only count with that you addressed in your 60B motion.
Yes.
Okay, thank you.
Yes.
Any final thoughts, Mr. Collins?
Yes, Your Honor, thank you. This case is about the obligations, fundamentally is about the obligations of the county within the framework of protecting burials and other historic properties under HRS 6E. And its obligations, constitutional obligations to protect the traditional and customary practices of the plaintiffs, the petitioner appellants. But we're here today because the trial court and the Intermediate Court of Appeals erred by avoiding the merits, haunted by the ghosts of Twombly, Iqbal, fact pleading and common law forms of actions, and technical constructions of the rules to deprive the plaintiffs of their ability to have the case heard on its merits. Our position is that as a matter of law, the plaintiffs, petitioner, appellants are entitled to summary judgment, actually, but that the rules should be construed to have its case considered on the merits, and to the extent that there is a mootness issue, that either the repetition but evading review exception applies or the public interest exception applies, and that the county be given guidance over how it is to use its powers with respect to historic properties, Hawaiian burials, and the constitutional right protected.
Did you raise kapa'akai below?
We didn't get that far, but yeah, can't do a kapa'akai analysis in 30 minutes. All right, thank you very much, Your
All
Honors.
right. Thank you to our attorneys for your arguments today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'o malolo ia mai nei ke a aha ho'o kolo kolo ki e hana hana. This Honorable Supreme Court is now recessed.